Yes, yes, yeah. Like your PPT is there with you, sir.
So
okay. Midusma ma'am, please start the introduction part of sir.
Yes, sir. I'll start. A very good afternoon to one and all. I am Midusma Nath, ISC coordinator of Assam Downtown University. Welcome you all for today's webinar. For today's session, we from Institution Innovation Council of Assam Downtown University has invited Mr. Subhasis Ghosh sir from Kolkata to deliver an enlightening talk on the topic that is overview on intellectual property rights. As we all of you know that intellectual property rights are legal rights that protect creation and invention resulting from the intellectual activity in the industrial, scientific, literary or artistic field. But this intelligible creation of human intellect are often found to be at risk and being plagiarized by and misused by unauthorized agents. So therefore an awareness program has been started. Its significance of intellectual property rights have become the need of the hour. The Institution Innovation Council of Assam Downtown University has taken the novel initiative of spreading awareness on intellectual property rights among the people through expert talk series, as this is our second session. Before also we have conducted some webinar. So as a part of the series, Assam Downtown University invites Mr. Subhasis Ghosh sir, founder of Synergy IPR, patent and trademark attorney and advocate and partner, to throw some light on the various unknown aspects of IPR. So before starting our main session, I would like to request Dr. Bhola Sorasia, convener of today's webinar and IIC activity coordinator of Assam Downtown University, to welcome to give the welcome speech. Over to you, sir.
Thank you, ma'am. On behalf of Assam Downtown University, we welcome Subhasis sir to deliver the lecture on intellectual property right. And after just going through the profile of sir has got huge experience about the copyright, about the patent, about the trademarks. And today we are very lucky enough to just listen to sir that what are the procedure we can apply for copyright, trademark, patent, etc. Welcome once again in Assam Downtown University, sir. So you can start your lecture.
Well, Dr. Chaurasia, I have to share that presentation with you. So,
yeah. Should we start from our side, sir?
Just a second.
Ma'am, please share the presentation, ma'am.
Yeah.
Ma'am, please share the presentation. Yeah.
Yes, sir. Before starting our main session, like before giving time to our speaker, I would like to give some brief introduction about our speaker. So many of may not know about sir, about his whatever.
Please go ahead. Yeah, please go ahead.
Mr. Subhasis sir is the founder of Synergy IPR, a boutique firm located in Kolkata, and it was established in 2008. And sir is a registered patent agent and advocate with MSc in Geology from Kolkata University. He was a rank holder in Kolkata University and have several publications in international journals. And he has industrial experience in companies like Esport India Limited, and also worked as a scientist at CSME, and he has expertise in domestic and international patent drafting and prosecution, then intellectual property licensing and litigation, then patent opposition and litigation, trademark and copyright prosecution, then opposition and litigation, as well as domestic and international design prosecution. And he was wide exposure to drafting of patent application in various fields, including mechanical system, then hydrogeology, environmental science, software and hardware, and natural product of chemistry and chemical processes. Specific areas of experience of SARS, it basically include like drilling, subsea drilling, then soft sediment analysis, solar cell technology, composite material and manufacturing, then optical disc technology, and chemical technology, mechanical engineering, then telecommunication system. And sir has his IP practice almost for 25 years, and sir represented Tata Consumer Products Limited, Kolkata University, then Jadavpur University, then IISCR Kolkata, then Center for Development of Advanced Computing, and Indian Council for Agriculture Research, and some other areas like AGOI Holding Corporation, then Orthofix SRL, then Synchron SRL. In addition, Subhashi sir has handled several design cancellation proceedings before the Indian Design Cell. So I hope that our participant will be benefited from sir's speech, and it will be a great session. Over to you, sir.
Yeah, Dr. Chaurasia,
Yes, sir.
if you can share that document.
Yes, sir. Ma'am, please start sharing the document.
Yes, sir.
Share the
Sir, I will share the PPT.
Okay. Okay, please do that.
Sir, is it visible?
Yes, it is visible.
Okay, sir.
Hello. কোনটা?
মুভিটা কোথায় গেল? বন্ধ করো না, ওটা খুলে রাখো, কল ট্যাপ করে।
Oh, sure. Yes. Hello. Shall we start now?
Yes, sir.
Okay.
Let's start, sir.
Okay. So, legal. What are the intellectual property or intellectual property rights? These, in brief, are legal or statutory rights of exclusive or monopolistic nature in respect of creating exercises of human intellect or intelligence. That means something which you create out of your intellect, to be very precise. These are actually your creations for which you can get monopoly right for a limited period of time, depending upon the type of intellectual property. Briefly, these are legal or statutory rights, exclusive or monopolistic rights, creations, etc., that is products of human intellect. Can we go to the next slide? So IPRs in general, or intellectual property rights, industrial property and copyright. Next slide, please. Now IPRs, no, this one. IPRs in the Indian context are patents, industrial designs, trademarks, geographical indications, and copyrights. If anything is I'm not able to convey properly, please let me know immediately. These are the 5 branches of intellectual property rights: patents, industrial designs, trademarks, geographical indications, and copyrights. Of course, given the short period, we cannot embrace everything under this under the umbrella of these 5 categories, but we'll try to explain to you how you can go about and procure intellectual property rights in respect of this. Next slide, please. First, let us go to trademark. So, what is a trademark? You often see in different products certain labels, certain names, and next to that you will find a number, an alphabet R written over there. That means that is your registered trademark. So, trademark indicates your goodwill and your branding. Say, for instance, trademark Tata. From there, you will understand it's a Tata product. There are various, I'll give you some examples. Trademarks can be related to goods or it can be related to services. Like it can be related to tea, coffee, cocoa, chocolate, thumbs up, or it may relate to, say, hospitality services. It can relate to medical services. So, mark includes devices, brand, label, ticket, etc. And right in a trademark is acquired by registration under Trademarks Act. There is a 1999 Act, which has, of course, been updated from time to time. Now, when you have to file a trademark, you have to give a representation. That comes in black and white. And if you give colors also, that means your trademark is restricted to that specific color. So it is always advisable to give only black and white marks. Can we go to the next slide? Here are certain examples like associated trademarks, like Bajaj, Bajaj Pulsar, Livomine Forte. Service marks are there, like Philips emblem, Fevicol label. It is composite mark comprising any part of distinctive nature, which is registrable independently. And marks nearly resembling one another, like Bajaj is the parent mark, and thereafter you have Bajaj Pulsar. So the Pulsar is actually a brand of Bajaj. The product Bajaj Pulsar indicates its Pulsar is the sub brand coming under the broad brand of Bajaj. And what are service marks? These are composite marks comprising any part of distinctive nature, which is registrable independently. And each mark can be registrable independently. Next slide, please. Hello?
Yes, sir.
It is echoing. Your voice is echoing.
Sir, you are audible, sir.
I'm audible. Actually, the problem is, if I can operate this presentation, that would be easier.
Then, sir, we will stop sharing the presentation. You will share from your side, sir.
Then how do I share that? Just give
Then, so we will share. Just keep on saying the change. We will do changing. Okay.
Now, what is there are certain other trademarks also, like certification marks. These marks are certified by the proprietor of the mark as to origin. Example, hog mark in relation to food and agriculture. When you say hog mark, that means it relates to agriculture. Wool mark, that is, it relates to woolen garments and materials. Next slide, please. Unregisterable trademarks, which are devoid of any distinctive character. That is to say, not capable of distinguishing the goods, which consist, say, of things which are descriptive type, immoral type, and which are not say, for example, if you have a mark which indicates the nature of the product, then you cannot have a trademark for that. It should not be describing that particular goods for which you want to apply the trademark directly. Next slide, please. There are certain marks which can cause deceive the public or cause confusion, which contains or comprising matter like which will hurt the religious sentiments of others. If it contains any obscene matter, it will not be registered. And if it something a trademark which consists exclusively of goods which result from the nature of the goods themselves or shape of goods, these are not registered. Next slide, please. So before filing any trademark application, you need to do a search to see whether your brand is clear. It may so happen that the brand which you have devised out of your brand, that might already exist in the market. So for that, you have to do a registrability search before you actually file for your trademark application and see whether that brand is available. Available in the sense that whether someone else is already using that brand. Then you should think of something else. Otherwise, later on, when you spend a lot of money on this particular brand, then what happens? Then you find yourself involved in litigation subsequently, and so on and so forth. So what is the procedure for registration? It is first filing, followed by examination, then acceptance takes place and publication. Then there is a provision for opposition by any person interested to things that if your mark is registered, his interest will be hampered. So he can file an opposition. And if there is no opposition, or if the opposition is decided in your favor, you can go for, then you can get the registration certificate automatically. Next, please. How to enforce the trademark? You can file a civil suit or file reliefs, injunction, or ante-pillar order for search and seizure of infringing documents. Or you can go for a criminal complaint like a magisterial order for search and seizure of the infringing goods. And for that, you have to take the services of a police officer, not below the rank of DSP, and also may search and seize the infringing goods after obtaining the opinion of the Registrar of Trademarks on the questions of infringement. The trademark registrar will give you an opinion that whether indeed it is infringement. Then you can take that to the DSP rank officer and ask for a magisterial order for search and seizure, and then take it to the to a police officer who is not below the rank of a DSP, and ask for seizure of the goods which are being infringed, which have your registered trademark. That means your goodwill is taken away. So you are trying to enforce your trademark and prevent the person who is taking away your goodwill and passing it off as if it is their mark, that is passing off your goodwill as theirs, and prevent them from doing that. So you can do it both by filing a civil suit and also by filing a criminal complaint. Next, please. See, the salient features of Trademarks Act, like it is registration, it can do service mark registration, it will do protection of well-known trademarks. There is a particular list where you have the trademarks enlisted by the registry, which are well-known marks. They are automatically protected across the border also in the neighboring countries. Then change in the civil jurisdiction of the courts. These are all very detailed aspects, which I don't think it is now within the scope of the of our discussion. So these are all elaborate aspects of the act, which we need to have just an overview. Next slide, please. It has provision of additional remedy against criminal offense and constitution of intellectual property appellate board, which at this moment is not functioning. You have to go to the High Court. And provision of single register of trademarks. It provides a single register for all trademarks, eliminating two parts of the register, namely Part A and Part B. Register of trademarks will enter your mark over there as an official document, and once it is registered, that mark gets entered in the register of trademarks. So that is the final step of getting your monopoly. Next slide, please. Next slide, please. The term validity of a trademark is now 10 years. Just collective mark means concept of registration of a collective mark. This has been of late introduced, that is, a collection of marks constitute a single distinctive mark which identifies your goods and services from others. Next slide, please. Now, the scope of infringement of the trademark has now been a bit widened. Like use of a registered trademark as part of a corporate name, or use of a mark which is identical or deceptively similar to a registered trademark, even in respect of dissimilar goods, that will be regarded as infringement of trademark. Like if the goods are different, but the name is similar, that also can constitute an infringement. Next slide, please. All these are done under the Paris Convention treaty. There's a priority claim which you can do. That means they will give you a same priority when a applicant from outside comes and files in India. He gets the Indian date. Likewise, when you go to, say, USA and take a application date of India, USA will give that date when you file the application in USA, and just vice versa. This is a bilateral agreement we have with Paris Convention countries. Next slide, please. And another thing I must tell you, now under the recent arrangement, even international marks, you can just file an international mark, say a mark which is filed, and now that you can extend in India. Under the convention, you can have it extended in India, but India government will have it examined in Indian context. But you don't have to file if you file the international trademark application. You have to just validate in India by filing the details of that, because the details will be sent to the Indian government, and then you have to designate India while filing. And once the details are sent to the Indian government, they will do a registration check and examination. And if it is true, then you get your protection in India also. Next slide, please. Now there is another intellectual property. So long we were discussing about trademarks. And regarding trademarks, another thing I must tell you that you can file a trademark application even if you don't use that mark. And also, if you have been using that mark, say, for 10 years, and today you want to file, that also is possible, because it comes under the Common Law Act. You have to claim the first use of that trademark, when you started using it. But you are filing it today, but you may have been using it 10 years back. So all this 10 years use will be accrued when you file the trademark application. For that, you have to give certain documents like invoices, advertisements, which are 10 years back, you have been using some 10 years for 10 years, or at least 5 years or 6 years. A few of such invoices and advertisements you have to give and file the application at a subsequent date, but yet get a use of a previous date. But that is not allowed in designs. Designs is protected under the Indian Designs Act. Novelty is absolute for designs. If that particular design is available anywhere in the world before you file the application, then you cannot get a protection for that. Now, for a design, protection is very limited. Shape, configuration, pattern, and ornament or composition of lines and colors. This is all you get a protection for a design. And what is the criteria for registrability? It is a concept which is applied on an article, and it has to be original and new, and significantly distinguishable from known designs. It may be a combination of known designs, but it should be, the culminating design should be identifiable distinctly from the known designs. So that is called original and new. New means something which is brand new. And original, I will give you an example. Say, if you have a cigarette case which is having the shape of, say, Qutub Minar. That Qutub Minar shape is known, but this concept of applying the shape to a new item, that is a cigarette case, that is new. So that comes under original. Next slide, please. Procedure is very easy. Just file the application before you use it anywhere in the world or publish it. Then it undergoes examination, and then if it is if novelty examination is okay, it is okayed by the parent office, then you get your registration certificate. The registration term is first 10 years, you don't have to pay any renewal fee, but after that, you have to pay one renewal fee. The total term is 15 years, 10 plus 5. And another thing is that even after registration of a design, at any time after the registration, an interested person, he may come and seek for cancellation of the design on certain grounds that this design is his design, or it was known publicly even before filing of the design. So a registered design is not ultimate. It may be cancelled as well. And what are the infringement action? There's a civil suit, reliefs, injunction, and damages. You can file a civil suit and obtain reliefs, and also obtain injunction and damages. Next slide, please. I don't know whether the discussion is becoming a bit boring. I'm not sure. Anyway.
Sir, discussion is very important for us, sir. We are just listening it properly, sir.
But it's fun because I'm not, the problem with this virtual discussion is there is no reaction from the outside, from the other side.
Yes, sir.
Normally, wherever I go for a speech, usually I get a lot of questions in the midst of my speech. So, but that I think is a bit restricted here. Okay, now marking of articles. Now, once the design is registered, you have to mark your article. Say it can be even a cup, a cup, or maybe a bottle like this, somewhat like this. Of course, it's a known bottle, but a bottle can have a new shape for which you have obtained a design. You have to mark on the bottle the registered design number. But if it is a very soft sort of an article, like say a textile, it's very difficult to mark on a textile. Then you are exempted from that. But unless you mark your article other than these exempted articles, then you cannot obtain infringement. So that is, marking is very important. You have to just give registered design number XYZ 1, 2, 3, 4, 5, 6 like that on your article. So design is obtained. Basically, what is the topic sentence? Design is obtained for a particular article, not like trademark where you have both goods and services. You have to have an article on which your design is applicable, and that design can be shape, configuration, combination of new colors, ornamental surface pattern. Now, importance of designs in commerce and industry, I think it is exclusively and hence edge over competitors. It gives you a monopoly right for 15 years. The others cannot use that same concept which you have applied on your article. Like even it can be cutlery, it can be a spoon, it can be anything, any article. And those are given classifications. You have to file a design according to the class to which that article falls. There are several classifications under the international scheme which India has adopted. That is called Locarno classification. That India has adopted, and there are several codes under that classification. And depending upon the nature of the article on which you are applying the design, you have to file your application based on that class. So it gives you edge over other competitors once you mark your product. Assignment or licensing facility is naturally there since it is your intellectual property. Just as you can sell your house, you can sell your design also. Builds up product image goodwill. Naturally, your design with people will understand it is the design of XYZ company. So it is aesthetically appealing to the eye. They will quickly purchase it. because of that aesthetic appealing when they go to purchase that article in the market. Next slide, please. Now we are going to copyright. That much about design. Copyright gives you, it's a very common topic which all of us frequently discuss. It gives you literary, dramatic, musical, or artistic work protection, or a cinematographic film, you can have a protection for that, and sound recordings. For film, producer is the owner. For sound recording, usually the music director. For literary, dramatic, musical, or artistic work, it is the author. Okay, this is the criterion for ownership of a copyright. So these are the three broad classes for which you can obtain a copyright. For a building also, you can obtain copyright. It will come under literary work, artistic work. I mean, the engineer, he can draw a building, draw the sketch of a building, and obtain a copyright on that under artistic work. Next slide, please. It discusses about the scope of works. Like literary work, it includes books, compilation, articles, magazines, stories, newspapers, and very importantly, computer programs. Software, which is absolutely software per se, that means which is nothing else but software, that can be protected by computer, that can be protected by a copyright. But when there is some development done on a software so that you can utilize some hardware also, that becomes a patent matter. That I will discuss later. Then dramatic work includes plays, any piece for recitation, choreographic work. Musical work includes work of music and graphical notation. You know what all this? Artistic work includes painting, sculpture, drawing, engraving, or photograph, including drawing the sketch of building. Next slide, please. Next slide, please. Cinematographic work includes any work of visual recording. Sound recording is a recording of sounds from which sounds may be produced. What is not sound recording also comes to some extent under music recording, because it is normally the subject of the music director. So what is not copyrightable? There is no copyright in ideas, nor in works devoid of originality. Right? If you copy someone else's story, you cannot have a copyright for that. Copyright subsists only in the material form in which the ideas are expressed. Work should be original and should not be a copy. Copyright in a work subsists as soon as the work comes into existence or is created. As soon as you finish or start working on a novel, a story, immediately copyright starts subsisting. But normally you have to register your copyright with the registry. Okay, that will help you to enforce your rights, because you can prove that you have a copyright for a certain work. But let me tell you, both for trademark and copyright, it is not mandatory to go for registration, but the courts always insist to go for registration, though it is optional, so that when you enforce your copyright or your trademark, that helps you a lot. Because when you go for enforcement, you have to approach the court. And if you can show the court that you have a registration for that, that means you care for your trademark, you care for your copyright. Next slide, please. Oh, well, this was just what I was telling you. Registration is not mandatory. Let's not go into that again. Now, conditions for registration. Work is first published in India, or it may not be published at all. Even if it is not published, you can go for a copyright for that particular work. Where the work is first published outside India, the author at the date of publication must be a citizen of India. If the publication was made after the author's death, the author must have been at the time of his death a citizen of India. These are more of bookish value. Normally, when you are a citizen of India, resident of India, it is expected you do your work in India. Not that you are here and your work is done in USA. But sometimes it happens. You may be a citizen of India but resident of USA, and you do something over there. This is in such conditions, this will be the explanation. Next, please. In case of unpublished work, the author is on the date of making of the work a citizen of India or domiciled in India. Just I was talking about unpublished work. You can also go for copyright for work which is not published. You have to file in India, and on the date of making of the work, you were domiciled in India or a citizen of India. In case of an architectural work, the work is located in India. Just I was talking about a building which is being drawn by an artist. So it is this building work is more of a work of architecture. It comes under Copyright Act. Like a building drawing, the delicacies, the internet, the internal works, the size and beautification of the rooms and all this. An artist and an architect nicely draws all this using his skill. So he is entitled to have a copyright for that under the work of architecture, which is also an artistic work. Procedure for registration is filing the application for copyright with the forms. You have to do it online these days. Scrutiny is done by the copyright registrar, and then issuance of the certificate is done by the registrar. Next slide, please. Generally, at the time of author, lifetime of author plus 60 years. Term of copyright. I'm talking of term of copyright. It is a work published anonymously or pseudo-anonymously 60 years from the date of first publication. Okay, if the author dies, then 60 years. As you know, in case of this famous Rabindranath Tagore, Gurudev Rabindranath Tagore, he already 60 years have expired from his death. So Rabindra Bharati, Vishwa Bharati, as to be precise, they used to have the copyright of all Gurudev's work. Now everyone is, singing Rabindra Sangeet, changing it and bringing it. Whether you like hearing it or not, that is another question. But there, everyone is now, making changes here and there in the Rabindra Sangeet and going away without being any sort of copyright infringement, because now it has become a public property. But at the same time, it is not advisable to misuse any good work. But legally speaking, no one can touch you if you want to amend the words or the tunes, etc., because the copyright no more exists in his work. Importance of copyright. Work relates to the author or the owner and generate enormous goodwill reputation. This is obvious. If it is your work, naturally the author's name will be there, and that is how it will come into prominence. It's a valuable asset which may be assigned or licensed. Licensing of copyright is very frequent and more, I should say, more strong in film industry, because normally the singers, before they actually deliver the song, they have to give away all their rights by an agreement to the music director. So the music director is having the final say, is the final owner. Singers should not have any sort of stake in the song. Similarly, the music director also at times, he has to assign his rights to the producer, who is ultimately, making funding the film. Next slide, please. Rights conferred under copyright. Quickly, I am telling you. Exclusive right to reproduce the work. You can make it as many copies as you want, since you are the owner of the copyright. You can reproduce your work. You can make copies of the work. You can communicate your work to the public. You can translate your work also. Like if you have done, say, in Ohomia, you have written a story. You can translate it into English or any other language, but right will be yours in each such translation under the Copyright Act. Adapt the work. You can adapt it for making slight changes. In case of computer program, additional right to sell or give on hire copies of computer program. You can sell your software which you have developed, or you can put it on a hire and get some revenue out of it. Next slide. Enforceability, it is absolutely a criminal offense to infringe copyright. Injunctions are damages or account of profits. How much profit you have made? Sorry, percentage of that you have to return back as damage. And how do you enforce it? You have to file a criminal complaint, the magisterial order for search and seizure of infringing copies. And cognizable offense is any police officer not below the rank of a sub-inspector may, without warrant, also search and seize the infringing copies. You can just file a police complaint, and a sub-inspector, he will visit the offices of the infringer and seize the copies. You can it would be more better if you can obtain a magisterial order for such seizure and place it before the police officer. Normally, they don't act unless you have a magisterial order. Next stage. Next slide, please. International treaties under which copyright is protected. It's Berne Convention. Work over here is also protected outside. The work which you copyright, this is the only IP right where you get a worldwide right. If you have a copyright protection, you can have that protection all over the world. That is point B, Universal Copyright Convention. It is under Berne Convention. The marking of copies of work with C. You must have been observing that after on each page, after the printout of some literary work, you will find the letter C written in this manner. That indicates that it is the copyright of the author. Well, that copyright may or may not be registered, but the moment as I discussed earlier, the moment this work is created, copyright subsists. Next stage, please. Next slide. Thank you. Now we come to geographical indications. Another type of protection, a bit different from copyright trademarks, which we discussed. Geographical indications includes name geographical. Precisely, the quality of the good is understood by the utterance of a specific geographic region, like Assam tea, like Darjeeling tea. Okay, I'll give you examples. So once you say Darjeeling tea or Assam tea, people understand the quality. The quality is assessed by the purchaser from a mention of a particular geographic region in the name of the product itself, engraved on the product. Geographical indication is related to goods. It is only related to goods, not to services like trademarks, where you find that trademarks can be both for goods and services. Goods like tea, coffee, chocolates, water, and services like hospitals, medical service, teaching service, educational institutions, and so on and so forth. But geographical indication, like designs, relates to goods only, which may be agricultural, natural, or manufactured, or any goods or handicraft or of industry, any type of good. And geographical indication essentially identifies the goods in terms of certain given on inherent quality, reputation, or other characteristic which is essentially attributable to their geographical region. This is what I was discussing. Next slide, please. Just a few very common examples: Scotch whiskey, Darjeeling tea, Assam tea, Himachal apples, Dehradun basmati rice. There are many, like Madhubani paints, and so on. What are the unregisterable geographical indications, use of which would likely to deceive or cause confusion? These are just like the trademark part, which would otherwise be disentitled to protection in a court, which comprises scandalous, obscene matter, which comprise or contain any matter likely to...
Kindly unmute yourself. You are mute, I think.
Shall I continue?
Yes, sir.
Which would otherwise be disentitled to protection in a court, which are determined to be generic name or indications of goods and are therefore not or ceased to be protected in their country of origin, or which have fallen into disuse in that country. Okay, something which is no more used. Very similar to trademarks. Next, please. Next slide, please. Thank you. That there is one more criteria, which, although literally true as to the territory, region, or locality, in which the goods originate, but falsely represent to the persons that the goods originated in another territory, region, or locality, as the case may be. Like Darjeeling tea, you say Sri Lankan tea. That is unregisterable. Procedure for registration: application, then examination, then acceptance and publication, opposition, registration. Procedure is the same like trademark. First, you have to apply, then it is examined by the GI body, which is in Chennai. If it is accepted, it is published. You know why it is published? Just like trademark, it is governed by Common Law Act. So it is published to the people who can see it and raise an objection if it hampers his interests. Maybe he was not involved. He was involved, but he was not included in the entire process. Or perhaps it is wrongly done. It is wrongly referring as a GI. There are several grounds. It is wrongly referring some product as a GI, which is not so. On this ground, you can file an opposition. And if you win, if someone wins the opposition, the owner gets the registration. And if there may not be any opposition at all, just like trademarks, then registration will be automatic. Next slide, please. The term of registration is perpetual or unlimited, provided renewed every 10 years. This is again like trademark. I just want to inform you, maybe I don't know whether I have told you, in trademarks also, a registration remains valid every 10 years. And just before expiry of 10 years, if you pay your fees, it is again extended. It is perpetual. You can keep on extending it, not like design. Design is a monopoly for a limited period. As I told you, 10 plus 5. That is true for patents also. Patent is 20 years. After that, it becomes public. Copyright also, although the term is much higher, but copyright is also a monopoly given for a large period of time, but it's a limited time. Beyond that, copyright becomes public. But trademark is not like that. Neither is GI. It is perpetual. Every 10 years, you have to keep on renewing it. As long as you can. It can remain valid for thousands, 2,000, 3,000 years. Theoretically, of course. Enforceability: infringement is civil and suit, relief, injunction, damage, order for delivery of infringing labels and indications. That is, they have to return all those to you, just like trademark. And criminal is taken from the GI Act was drafted much later, and it is very similar to the Trademark Act. A criminal complaint and the magisterial order for search and seizure, and the police officer not below the rank of DSP may search and seize the infringing goods. So magisterial order will be automatic, search will take place. Or with that magisterial order, you can file an application with the officer not below the rank of a DSP, and he will do the seizure or instruct his people. That is enforceability of GI. Next slide, please. Thank you. Importance of geographical indication in commerce and industry builds up enormous goodwill and reputation in respect of goods. The reputation of the first GI in India was Darjeeling tea. The reputation of Darjeeling tea as something. The moment you see it is engraved over there, you understand the quality of tea. When you say Madhubani paints, you know what sort of paints are there. In Nagpur also you have the oranges, I think. And of late in this West Bengal Department of Science and Technology, they have won some opposition against the state of Orissa regarding Kolkata Rasagolla. Okay, Kolkata Rasagolla. That is a GI now. It was opposed by the state of Orissa. But the Kolkata Rasagolla DST, West Bengal DST has won the case. It is now Kolkata Rasagolla. That is a GI. So marking of goods, registered geographical indication or RGI. There you have to mention that it is registered under geographical indication on your product. Next, please. Now we come to patents. Before I start all this, I must tell you that in patents also, like designs, novelty is absolute. You cannot file a patent application for an invention which is already published or marketed or used by public. You have to first file and then go for any sort of use. Even if it is published in Afghanistan, you cannot file a patent anywhere in the world. Just for example, if it is published in USA, in the website, you suddenly, in these days of high-tech technology, high-tech world, you can always, access different databases right from your office, right from your lab, and you can avail many things. And if you see one particular paper is already published and someone is getting a patent for that, you can file an opposition and get it cancelled. So first thing we tell our clients is don't go for any sort of publication, any sort of advertisement before your patent application is filed. And what does it require? It requires a write-up from your end, indicating what is already known and what are the improvements you have made, with the help of some examples, with the help of some drawings, particularly for mechanical engineering cases, examples particularly for pharmaceutical and chemical cases. Then we prepare a draft of the specification, which you approve, it gets filed. Now we see what happens here. In India, a patent application can be filed as a non-convention application. What is a non-convention application? That is the first ordinary application you file in India. You have devised something in your brain, perhaps someone has drafted a specification and filed it. That is the first application, non-convention application. What is the convention application? 2. You have filed an application in USA. Okay. Now you want to protect that particular invention in India also. You file an application in India within 12 months from that US application. Under the prior Paris Convention bilateral treaty, when you file the Indian application, you get that US application date in respect of priority of the invention. That means if there is any publication in between, that will not destroy your invention and will not prevent you from filing in India, and vice versa. Like if you file an application in India and within 12 months you go to USA or any other Paris Convention country, to Japan, to China, to Australia, to Europe, and file another application, and within this period if there is any publication, that will not hamper, because you get this Indian filing date. You mean someone or some overseas applicant in respect of priority, so that your novelty is not destroyed. And what is PCT national phase? The third type. PCT national phase is an international application. You have to file that international PCT application designating. Now I think there are around more than 200 countries. You can designate them and get your application examined by the PCT examining authority. Maybe India, maybe Australia. That depends upon what choice you make and what fees you give. Now, if you see that your examination report is good, now you get 31 months time to enter your applications in the countries of your interest. As I told you, like copyright, it is the only intellectual property which is protected worldwide. All other intellectual property, you have to go for specific protection in specific countries. In trademark, there is some facility. As I told you, there is an international application which may be filed and it may be examined in India, and you can get a registration. India is now a party to that system. Previously, they were not. So point number 2 is what I was telling you. The entry deadline for national phase is 31 months from the priority date. Okay. Now, PCT national phase, I hope I have explained. It doesn't give you any global right. It is just an assessment authority, which before you file in different countries gives you some idea about where your invention starts in respect of novelty and its inventive state. What are the, frankly speaking, or more crudely speaking, what are the possibilities of getting a patent for that particular invention in different countries? PCT will make an assessment and then PCT will expire. This is a frequent mistake which the inventors make. That I have filed a PCT application, I am going to get a global patent. Nothing exists on this earth called global patent. Okay, everywhere you have to file a patent application in different countries to obtain protection in those countries. Now, non-convention application deadline is as soon as you can before publishing the invention. Convention application deadline is 12 months from the basic application. PCT national phase is 31 months from the priority date. That is the first application which you have filed. In India, patents are now coming to the rules and coming to the different law and rules of the Indian Patents Act and rules. How these rules and acts actually govern your invention and how you can overcome them to obtain eventually a patent. Patents are granted for a new and inventive product or method process. Claims for use, second medical use, method of treatment are not allowed. Like if you say use of a compound X for treatment of say psoriasis, and that compound X, is already known for treatment of cardiac failure. So that second use you cannot have. You can have only protection for the product, and you cannot have any claim for use. And method of treatment of human beings or animals cannot be protected in India. Next slide, please. Application or product by process claim is not allowed. Like if a product obtained by the process, if you put your claim like this, it will not be allowed. Composition claims are allowed. Composition claim means there can be a mixture of compounds A, B, C, D, E to form a composition in different proportions, which gives certain new effect, an unexpected effect, a synergistic effect. Such composition can be protected. Single known active ingredient based claims are not allowed. Like if you have a composition, with A, B, C, and you find B and C, are mere carriers. It is A only in the composition. So it is A, basically, the active ingredient. Such claims are not allowed. In case of pharmaceutical chemical cases, it is required to prove the enhanced efficacy, which I was telling you that if you have some enhancement of the efficacy by virtue of your composition, then you can go for a composition claim and get a patent for that. Anything related to atomic energy, if your invention is related to disposal of atomic energy or use of atomic energy or any sort of use, then you cannot get a patent for that. Next slide, please. Publication of patent application may be withheld by the government if it is found to be relevant for defense purpose. If the government finds that your invention is relating to defense of India, and if it is published, then your enemy country might get some impetus and attack you. So in such cases, they will withhold the publication. They will, of course, inform you. Otherwise, invention in India is automatically published within 18 months from the filing date, or where it is applicable, the priority date, if it is a convention application. An invention developed by an Indian resident inventor must be filed first in India and can be filed in foreign countries after 6 weeks. Here, there is a system that if you are a resident of India, then if you want to file a patent application in USA, you have to give a small write-up to the government and obtain a permission from them. Or you have to file an Indian application and wait for 6 weeks. Then you can file in USA. An invention developed by Indian resident inventor can be filed in foreign country without filing first in India, as I told you. Amendment of a specification can be made both before and after grant of a patent. However, the scope of amended claims must not go beyond the scope. It is saying that you are having some claims, say with 5 components, A, B, C, D, E, F. Now, all of a sudden, you make an amendment that you are having only three components, A, B, C. That means your claim becomes more wide. That is not allowed. You can add, but you cannot subtract something from your claim and make it wide. You can narrow it down by adding more features. Next slide, please. There are certain inventions, in certain specifications which can have more than one invention. But in India and all over the world, patents are granted for a single invention. What to do for the other invention which is there in your specification? Anytime before grant of the parent, you can file a division. Publication, I have told you, 18 months from the priority date. And another thing I should tell you that provisional specification can be filed at the moment anything comes in your brain. And then once it gets developed in 12 months, you will have to file a complete specification. So an application, ordinary application can be filed either with a provisional specification or with a complete specification. If your invention is complete, if you think no other developments are needed, you can straight away file a complete specification. But if you think just that you have just got hold of the idea, then for that particular thing you can file a provisional specification and file a complete specification within 12 months when more developments take place. Infringement suit in respect of patents is civil infringement, civil suit. It can be filed only after grant of a patent, but you will get protection from the date of publication of your patent, which is 18 months from the priority date. There can be early publication also, ordinary applications. If you file an application, it can be published early. Likewise, subject to satisfaction of certain criteria, you can also file a request for expedited examination. Otherwise, your examination report has to be filed within, examination request has to be filed within 48 months from priority date. Then the application will be examined. Infringement suit can only be filed after grant of a patent. And patent is 20 years from date of patent. What is the date of patent? Date of patent is the date of filing in India. And for PCT application, it is the date of filing the PCT application. This thing I may have missed during the discussion, that when you file a PCT application, you get that PCT filing date when you make the entries in India or elsewhere or in XYZ countries. Wherever you enter within 31 months from the priority date of the PCT application, you will get the PCT filing date over there. Okay, so that will be your date of patent, and you will have 20 years time, 20 years monopoly rights from that date of patent, after which your patent becomes public property. Renewal fees are required to be filed after grant of the patent, and it is taken from the 3rd year till the 20th year. But sometimes, most of the time, in the 3rd year the patent is not granted, so you get it, the annuity gets accumulated, and that you have to clear within 3 months from the date of grant. So basically, the process in respect of patents is like this. First, you file an application, then you file the request for examination. The examination report is issued. You get 6 months time to comply with all requirements or to give your arguments, and then the patent gets granted if there is no pre-grant opposition. Patents Act has a provision for pre-grant opposition. That is, any time before grant, opposition by any interested person or any person whose interest is hampered, he can file. And even after grant, there can be post-grant opposition can be filed. There are timelines. And at any time after grant of patent, just like designs, you can go for revocation of the patent on several grounds, including prior publication before the application was filed. So nothing is ultimate. Non-payment of annuity leads to lapse of patent. Next slide, please. A lapsed patent can be restored within 18 months. So that also is possible. If you forget to give the renewal fees, you get 18 months time from the date of cease, and you can file a request, and you can ultimately get it regularized on payment of the pending fees. Request for examination, which I told you, has to be filed within 48 months of the priority date. And for a divisional application, it has to be 6 months of the filing or 48 months, whichever is earlier. Examination is carried out in order for request for examination. This I have already discussed with you. Number 26, that is request for expedited examination. You have to pay extra fee and subject to fulfillment of certain specific conditions, like you have to be government organization. First applicant can be a female, and several other. If you are MSME, then also it is possible. Normally, it takes about 12 to 24 months from the request for examination for the first office action to issue. Next slide, please. The applicants get 6 months to comply with all requirements and to place the application in order for grant. This I discussed with you already. It is advisable to file a response to first office action within 3 months. The earlier you do, the better. So once you get the FER, first examination report, it's better to respond to it with all amendments, preferably within 3 months, so that the controller also has time at his end to expedite and dispose it a bit faster. But normally, it is not always true. The controller takes his sweet time. But usually these days, due to the increasing number of controllers and examiners, patents are granted within 2 to 2.5 years from date of filing. After 6 months deadline, there will be no new office action. But this 6 months deadline can be extended by 3 months. And after expiry of the 6 months plus 3 months, suppose there are still certain objections, then he will give a hearing. Just before joining this session, I was in a patent hearing because the controller found several objections pending even after the last day. So a hearing was given to us, which we have attended and offered submissions. 2 adjournments of 1 month are available for the oral hearing. Suppose you need more time to attend the hearing, you can go for adjournment. This is a very standard procedure. Next step, please. Applicant must file a written submission within 15 days. That is, after the hearing, you have to give during the hearing oral submissions and follow it up within 15 days with your written submissions, just like the court. After hearing, the IPO issues its decision of grant. If it is granted, it's fine, as it happens most of the cases. Otherwise, it will refuse the application, and then you have to go to the High Court challenging the appeal. Challenging the refusal. You can also file review petition before the controller within 1 month from the issuance of the controller's order. In India, there are provisions for both pre-grant and post-grant opposition, which I already discussed. Pre-grant means any time before grant, anyone can file. Post-grant is after the patent is granted, it is notified in the Gazette, official journal of the Indian Patent Office. And within 1 year from such advertisement of grant, any interested person, he has to establish that he is interested. He can file a post-grant opposition. At the first point, he has to establish before the controller what his status, that he is indeed an interested person. And how he is an interested person, he has to show that how his business is being affected. And he is also in the same business. But for pre-grant opposition, there is no such requirement. Any person can file. And there is no charges also, unlike post-grant opposition. You can find pre-grant opposition free of cost without paying official fee. A person interested can file post-grant opposition till 1 year from the date of grant. Date of grant, normally grant is the day the grant is done, on the same date it is put in the journal. So it becomes the date of grant. Next slide, please. Revocation can be done anytime during the term of a patent, just like designs. A suit of infringement can be brought before a district court. However, if there is a counterclaim for revocation, let me explain this. What is the counterclaim for revocation? Suppose I have a patent and some X infringes it. And that X infringes it in, say, in a district, particular district. So that I have to file that infringement suit in that particular district court. Now, then what Y does, he files a counterclaim for revocation, showing that my patent is not enforceable. Because this patent needs to be revoked. Then it gets transferred to the High Court. And the High Court decides on the revocation petition and also the infringement suit together. The infringing relief action includes temporary and permanent injunction, damages, and or account of profit. or civil damages. The infringing goods can also be seized, forfeited, and destroyed if it is so decided by the court. A working statement for each patent must be filed. Every year you have to file a working statement. How far you have worked your patent. Next slide, please. These are all certain specific requirements like compulsory license. After 3 years of grant of a patent, primarily on the ground that reasonable requirements of the public have not been met, patent is not worked in India, then a person interested can go for compulsory license. There are very few such cases, and normally these are very few. These are more of theoretical importance. Another very important thing is a small entity and also educational institutions and MSMEs, they have been offered substantial carteling in respect of official fee. Of late, this has been introduced to encourage more and more patents. Even overseas applicants, if they have a small entity status, they will get a concession, a substantial concession in the official fee. All educational institutions, individuals, just like individuals, educational institutions are also entitled to get substantial cartelment in the official fee. Next slide, please. These are all how to get this cartelment. You have to upload necessary documents, and if there are certain corrections to be made in your specification, if it does not widen the scope, you can make clerical errors, you can correct them by paying the fee. And important thing in 54 is if there are more than one patent applicant, say there are 5 applicants in a particular patent application. Once the patent is granted, unless it is specifically mentioned, all 5 of them will have equal rights. Each will have 1/5 right. Next slide, please. Filing information, requirements and information, which I have already discussed. PCT publication, if it is not in English, verified English translation is needed. Basic filing fee is applicable for 30 pages, 10 claims and 1 priority. Beyond that, extra page, additional fee you have to give. Once you file, you get a cash book receipt and followed up by a application filing receipt. Next stage, please. Next. A power of authority, you can do it all on your own. But normally, you engage in an attorney or an expert in this profession who can help you. So you have to give a power of authority. And if you are filing in the name of a company of course cannot be an inventor. Inventor can be individuals only. So you have to give an assignment to the company. This can be filed in 3 months from the filing date. And for overseas applications, or Indian applications also, if you have corresponding applications in other countries for the same invention, and what is the status of those inventions, what is going on in those cases, you have to inform the Indian controller. Next slide, please. This is all about verified English translation of priority document, which I was telling you. If it is not in English, if you have obtained priority from USA, you have to give a US document over here. If it is, but in USA it is in English, but if it is a Japanese document, you will have to file a verified English translation. Because Indian government accepts only documents in English and theoretically in Hindi also, which is hardly done. This is prosecution details, which I was telling you, that if you have filed in other countries, what has happened to such applications, what sort of examinations have been done, whether they have been refused, if refused, what are the rejection grounds and all this, you have to give it to your Indian controller. When you, within a stipulated time, within 6 months, you have to give it. If the Indian application is examined and the Indian controller asks for it. Next slide, please. Well, that brings us to the end. If you have any questions, you please let us know. Let me know. Otherwise, we are finished.
Thank you so much, sir, for your brief introduction and about the IPR. We came to know so many hidden aspects of
I have been very
IPR.
fast, I'm sorry about that because there are too many things. So I was a bit fast. I'm sorry about it.
Yes, sir. I hope our participants will be benefited from this session. So now it's time for discussion, query, or any question you have, then you can ask.
And thank you for your help also in for sharing the PowerPoint presentation.
Welcome, sir. Anyone have any question or any query?
Well, you can mail them to me also if you cannot. If you have
Yes, sir.
subsequent questions, you can mail them to me. I'll respond. No problem. My contact
Okay,
details
sir.
are all available with
Yes,
me.
sir. Yes, sir. We have.
Yeah. But I would be
Okay,
happy
so-
if any question is there.
Yes.
Maybe I have overloaded too much.
I think, sir, we can.
So one question from my side.
Please.
Sir, can the recipes can be copyright? Can my personal recipe can be copyright?
Recipe,
Like,
it
a
is
recipe
more
of
of a
food recipe. Yeah, food item. Yeah,
it is more of a patent matter. Okay.
patent better.
Recipe, more
Okay.
of a patent.
Okay, fine.
For
Thank you.
copyright, as I told you, it has to be literary work or musical work, sound recording, work of
Okay,
architecture.
but sir, in some of my contact, I have seen that one or two like a friend of mine, they have done copyright of the recipes. I don't know what they have written in that.
Yeah,
Maybe
again, that
some
we have to see whether it
literary
is
work they have written. Maybe, yeah,
maybe they have written in the form of a story. Normally-
yeah. Maybe. So
Normally,
maybe.
recipes have specific steps, right? They are not
Okay, yeah.
a matter of copyright
Okay, fine.
because it is
Thank you,
not
sir.
artistic work after all. Or
Okay,
literary work.
fine.
You can go for patent. There are a lot of patents on recipes. Let me tell you, lot of patents.
Okay,
Particularly India patents filed by Indian applicants.
okay,
I have seen. I have drafted method for preparing dosa.
okay,
One person from South India. He
okay.
has a patent. I don't know how far he has implemented it. That I don't know.
Hmm.
But method for preparing dosa is patented.
Okay, fine.
Okay, so now I would like to request Dr. Bhola Surase, sir, the convener of today's webinar, to give his vote of thanks.
Uh, Thank you, for the wonderful speech and the wonderful knowledge we have gathered about the trademark, about the claims, the first user of the trademarks, about the invoices, about the design. Novelty is always there. Registration of the design can be damaged. License of the copyright is very important. About the GI, geographical indicator like Assam tea, Darjeeling tea, Kolkata Rasgulla, we have all learned, and about the patent also. Uh, and obviously, like after this webinar, our faculty members and the student will apply for the trademark, the copyright, the patent, the GI. And in future, if we are in any doubts, we will contact you. And really thank you to enlighten us with a wonderful knowledge and that we have gathered, sir. Thank you so much, sir.
Yeah, my pleasure. Thank you.
Thank you, sir.
Thank you, sir.
Okay.
Thank you,
Ma'am, you can
everyone.
end our session. Thank you, sir.
Yes, sir. Thank you, sir, for having with us, and thank you all the participants for joining us.
Thank you.
If you have anyone have any doubt or anything, then you can mail to sir. We'll give the
Sure.
mail to you. So we can wind up here. Thank you, everyone.
Okay. Okay. Bye bye. Bye bye.